Okay, live will be started very soon. On today's session on point of doctrine of basic structure. Earlier I have mentioned regarding this aspect how to establish the doctrine of basic structure. So this is the present situation, which is very much crucial not to abrogate the doctrine of basic structure. It is the challenge to Mr. Ali Riza. So how can he will exercise his power to supersede the doctrine of basic structure? So superseding and employing the structural pattern in terms of doctrine of necessity. The basic structures of our constitution may be hampered, as this is the doctrine of necessity. So no matter today's session on point of the doctrine of basic structure, and then we will discuss in terms of several questions from the side of the Bar Council exam in Bengali session. But at present I would like to discuss in terms of doctrine of basic structure. So just share this live video and hear the situation. On what point this is the doctrine of basic structure will be practiced in our country. And not only that, in every and most of the countries follow this instruction in terms of recognition. So Dibarwana Jabin and MD Habib Hossein and Al Hadi are watching this video with me. First of all, I would like to focus on point of the basic structure. So this is the doctrine. The basic structure doctrine is a common law legal doctrine. This is the common law legal doctrine that the constitution of a sovereign state has certain characteristics that cannot be erased by its legislature. So this is the challenge to Mr. Ali Riza, how to actually erase the constitutional mandate which is upholds in several in terms of the preamble, not in Article 7b. Those are the basic structure of our constitution. So this is the challenge to Mr. Ali Riza. And it is very much difficult to change the constitution. But this is the fruitful effect from the hopeful situation like this, the doctrine of necessity. On 5 August, Dafa Ek. So in this situation, there may be any change may be occurred in our constitution. So the doctrine is recognized at first in India. You have all know in this regard. Doctrine of basic structure may be recognized at first in India. So the singer, the genius singer Shohanur Rahman is watching this video. At first, the doctrine is recognized in India, Bangladesh, Pakistan and Uganda. It was developed by the Supreme Court of India. Alamin Shwaka is watching this video, but unfortunately this is the hampering system from the side of how to actually change that situational cases and the doctrine of basic structures from the side of the newly formed government, interim government. This is the critical difficulties which will be arised. So it was developed by the Supreme Court of India in a series of constitutional law cases in the 1916s and 1917s and culminated in Keshavananda Bharati versus State of Kerala. There are many landmark decisions in this regard, how to actually abrogate, how to change the doctrine of basic structure of the constitutions, which actually first the written constitution. So there is a supremacy of the constitution. So there is a distinction between the two constitutions, and there is like this, the supremacy of the constitution and parliamentary supremacy of the parliament in UK. So what is it? What the doctrine was formally adopted in Bangladesh in perhaps the only legal system in the world which recognized the doctrine of which and expressed written and rigid constitution of MENA through Article 7b of its constitution in our country, in our state. So this is the challenge to Mr. Ali Riza. And before earlier this duties entrusted to Mr. Shadin Malik. Wow, but this is very much difficult for him. In Keshavananda, Justice Hans Ras Khanna propounded that the Constitution of India has certain basic features and that can't be altered or destroyed through amendments by the Parliament of India. So it's very difficult to Mr. Alidias. The key among these basic features, as expounded by Justice Khanna, are the fundamental rights granted in individuals by the Constitution. The doctrine thus from the basic of the power of the Supreme Court of India to review and strike down the constitutional amendments and acts enacted by the Parliament which conflict with or seek to alter this basic structure of the Constitution. The basic features of the Constitution have not been explicit or explicitly defined by the judiciary, and the claim of any particular feature of the Constitution to be a basic feature is determined by the court in each what exact case that comes before it. The Supreme Court's initial position on constitutional amendments had been that any part of the Constitution was amendable and that the Parliament might, by passing a Constitutional Amendment Act in compliance with the requirements of Article 368 of the Indian Constitution, amend any provision of the Constitution including the fundamental rights and Article 368. This is entrusted and this is found in the Constitution of India, the biggest constitution in the world. Wow. But the recognition in every state there is a possibility not to change the systematic ways, and that's why this is very much difficult to Mr. Alias how to change this the systematic way. In 1967, the Supreme Court reversed its earlier decision in Goloknath versus State of Punjab. This is another landmark decision. But no one watching these videos, as we have no knowledge at all, and that's why this is the ignorant people living in the country like Bangladesh. So this is not easy to understand. So the Goloknath versus State of Punjab, like this is the decision which is superseded. This is reversed its earlier decision in Goloknath versus State of Punjab. It held that the fundamental rights included in Part 3 of the Constitution are given in a transcendent position and are beyond the reach of Parliament. It also declared that the amendment and tracks event breaches of fundamental rights conferred by Part 3 as unconstitutional. In 1973, the basic structure doctrine was formally introduced with rigorous legal reasoning and Justice Hans Ras Khanna's decisive judgment in the landmark decision of what exactly the Keshavananda Bharati versus State of Kerala in 1973. Previously, the Supreme Court had held the power of Parliament to amend the Constitution was unfettered. However, this is the landmark ruling and the decision. The court adjudicated that where the Parliament has very powers, it did not have the power to destroy or emasculate the basic elements of the fundamental feature of the Constitution. This is well known to you. And that's why this is very much difficult to Mr. Ali Riaz how to actually change this situation. well, there's an option, another option to change this situation in terms of and by applying this doctrine of necessity to validate the martial law systematic way. So this is the very much difficult. Although Keshavananda Bharati case was decided by a narrow margin of 7 and 12, the basic structure doctrine as propounded in Justice Khanna's judgment has since gained widespread legal and scholarly acceptance due to a number of subsequent cases and judgments relying heavily upon its order strike down the parliamentary amendments that were held to be violative of the basic structure and therefore unconstitutional. Primary among these was the imposition of the state of emergency and Indira Gandhi in 1974. And Kamalesh Raja is watching this video. So this is the 1974 and her subsequent apprehension of the majority bench. As you are the students of Dhaka University, you must have read on what actually the happening moment from the side of Keshavananda Bharati versus the state of Kerala and the superseding power in terms of the Goloknath case. Just write down what I actually delivered to you. So this is the hampering system, and this is very much difficult to Mr. Ali Riaz how to actually supersede that situational cases. So another language is in the, this is the Indian National Congress majority in central and the state legislature provided. In fact, such apprehension was well grounded in Indira Nehru Gandhi versus Rajnaran and Minerva Mills versus Union of India. The constitution based in Supreme Court used the basic structure doctrine of a strike down the 90, I forget that this is the 39 maybe amendment and part of the 42 amendment respectively and paved the way for the restoration of the Indian democracy. So the systematic way in terms of the Keshavananda case will be superseded in later cases. So this is the this is the fucking approach and fucking judgment from the side of the Supreme Court of India and in our country. The Supreme Court position on constitutional amendments laid down its judgment. Its parliament can amend the constitution but cannot destroy its basic structure. So what is the thematic approach in terms of basic structure? Whether it is possible to amend the systematic way which is ancient in Article 7 and every article which is actually interested in terms of basic structure of our constitution. This is the challenge to Mr. Ali Riaz. And that's why this was the challenge to Shahidin Malik, and that's why he formed these situational cases. The basic structure doctrine was rejected by the High Court of Singapore. It was initially also rejected by the Federal Court of Malaysia, but it was later accepted by its controversy. The doctrine was initially improved in Balice by the Supreme Court, but was later reversed on appeal of the Balice Court of Appeal. So this is the fucking approach towards the systematic way. Those who are the justice of the Supreme Court, so they have no knowledge at all how to apply. So this is the systematic way which will become from the side of the politician exactly, whether from the politician will exercise the power as they are ignorant no matter how high soever. So you are the Chief Justice and how high soever you have no will at all. So this is actually defending systematic way in terms of the political party. So the definition prescribes that the constitution has various features was first Mr. Just Right and systematic way. How can actually understand the Keshavananda Bharati case and superseding power in Goloknath case, Minerva Mills case, and how the systematic way in our country, Anwar Hussain Chaudhary versus Bangladesh 49, maybe 41, DLR Appellate Division, page number 165. This is the fucking judgment also. So that the constitution's basic was first theorist in the 1964 maybe. I don't know the recalling system in terms of the hearing system. This is the memorizing part. And maybe 1964 the constitution has basic feature was first theorized. What exactly the theorized? I don't know. This is the categorical aspect in terms of theory. Of course, this is the doctrine in 1964 by Justice J.R. Madhukar in his dissent. In the case of Shahjahan Singh versus State of Rajasthan, he wrote, it was made for consideration whether making a change in the basic feature of the constitution can be regarded merely as an amendment of, and would it be lie in effect rewriting for of the constitution, and if it later would it be within the review of the Article 368 of the Indian Constitution. Supreme Court through this decisive judgment of the Justice A.S. Khannas in Keshavananda Bharati versus State of Kerala, maybe 1973. This is the alignment decision in terms of this applicability and recognition in terms of the doctrine of basic structure. But what exactly the doctrine of basic structure? What is the basic features of the Indian Constitution? And in our country, like the Bangladesh Constitution, we don't know, but we have some knowledge, and somehow we actually explain in such a way. First of all, we would like to focus in terms of the maybe 20 basic features of the Indian Constitution. Like was the first of all is the supremacy of the Constitution. Of course, this is the supremacy of the Constitution. This is distinguished from the parliamentary supremacy of UK. There is a distinction between the two. So the first of all, the Indian Constitution prescribes in terms of supremacy of the Constitution. There's no value of parliament like UK. So this is the Constitution of the judiciary, and then rule of law. What exactly the Dryce's proposition and the propounding media in terms of the rule of law. Of course, this is by the rule of law, but this is being not practiced in the whole world. And the third one is the principle of separation of powers, that the balance of powers, which will be actually safeguarded position in terms of check and balance theory in USA. But this is not found in our country at all. The principle of separation of powers. Yes, this is the separated judiciary, but this is not independent at all. And then the objectives of it specified in the preamble to the Constitution of India, and what as well as in our Constitution, that the preamble was the historic liberation war. This is treated as to the basic pillar, but unfortunately the 5 August prescribes that this is the recent version from the Dr. Yunus, how the fucking approach from the side of Dr. Yunus. So this is the shampoo of the whole nation. And then judicial review is the basic structure in what exactly the appalling nature in terms of the Indira Nehru Gandhi versus Nazarine. Whatever Nazarine may be, I don't know. Several times and earlier I have focused in this regard, but at present I'm not actually practicing how to deliver the speaking power towards the audience and viewers in the online dunya. So judicial review the form, and then Article 32 and 226 in the Indian Constitution. But exactly the comparing made how to comparatively study to our Constitution, as this Constitution is borrowed from the Indian Constitution. Well, this is well known to you. And then federalism, including financial liberty of the states, and Article 282 and 293 maybe, I don't know. And then secularism, well known to you. This is the well established approach in terms of secularism, the Modi government, the sovereign democratic and republican structure, and then freedom and dignity of the individual. What exactly the freedom and dignity of the individual? This is the fucking approach. This is not being practiced in every section. This is not recognized in the whole world. But sometimes the good thing will be prescribed, but the bad thing will be done day by day, and we are going to darkness. And we are very much ignorant, not to grasp, not to comprehend. Just focusing freedom and dignity of the individual is a fucking approach in the whole world. Unity and integrity of the nation. So there is no unity and integration of the nation. But the unfortunate that the outcome of 5 August prescribed that the maybe unity and integrity of the nation will be increased day by day. So the Dabi Act, and then the principle of equality. This is the fucking approach in the history of the laws. The principle of equality. Not every feature of equality, but the what exactly quintessence of equal justice. Equal justice is not being practiced at all. But the recognition, there is no question maybe arise. But unfortunately, this is the basic feature of the constitution of the Indian Constitution and the Bangladesh, Bali's, Canada, USA. What exactly those who actually attack the written Constitution, except UK, or the Saudi Arabia, or the New Zealand. So what exactly the balance between the fundamental rights and directive principles? So what exactly the directive principle exactly? We know fundamental principle of state policy, which is covered in terms of Kudrat Ilahi Punir versus Bangladesh. So this is the upholding nature, the judgment in terms of the Kudrat Ilahi Punir versus Bangladesh. Maybe for it, for the appellate division number, what exactly 309? I don't know. This is the recalling system that those which is memorizable for. The principle of free and fair election. This is the fucking approach in the whole world. There is no, in everywhere, there is no option to fair and free election. Limitation upon the amending power conferred by Article 306 to it, and this is independence of judiciary. There is no question. This is the well decorated speaking, and this is the ethical approach, and what exactly the true purpose and the truly speaking is that an independence of judiciary is not being practiced in the whole world. And the judges and justices under the ambit of the power of the exercising colorable power and the arbitrary power from the side of the party in power, that the politicians and those who are practicing Tory politics in the war. So effective accords to justice and powers of Supreme Court of India and Article 300, maybe 32 and 136 and 141 and the 142. Maybe, but several times I have forgot which article exactly prescribed regarding this. So it is hampering system towards the Mr. Alirias, how to actually supersede this situation, this the difficulty in his life. So background doesn't prescribe in this fact, like first background prescribed in terms of the Keshavananda Bharati case and then Goloknath case. So in 1970, maybe 67, I don't know if this is the forwarding approach in terms of the hearing system, please forgive me. And see the Goloknath case prescribed in 1967, the Supreme Court reversed its earlier decision in Goloknath versus State of Punjab. A bench of 11 judges, oh my God, a bench of 11 judges, the largest ever in the trial, at the trial of the Supreme Court, deliberated as to whether the part of the fundamental rights provisions of the Constitution could be revoked or limited by amendment of the Constitution, whether it is impossible or possible, please. So the fundamental rights provision of the Constitution could be revoked or limited by the amendment of the Constitution. The Supreme Court deliberated its ruling by a majority of 6-5. And 24 February 1967, the court held that the amendment of the Constitution is a legislative process and that an amendment under Article 368 is law within the meaning of Article 13 of the Constitution. And therefore, if the fundamental rights are for the abuses of fundamental rights conferred by Part 3 and its void Article 13 sub-Article 2 reads the state shall not make any law which takes away over abuses the right conferred by this part. Of course, what exactly this part prescribes the third part? And every was made in contravention of this clause shall to the extent of contravention be void. So this is the formation and for reaching effect towards the constitutional amendment in Goloknath case. Well, but the Keshavananda Bharati case 1973 maybe, Keshavananda Bharati versus State of Kerala, 6 years later, after Goloknath case, 6 years later, of course 6 years later, what exactly the 6 years later, 67 to 73 prescribed that the 6 years later. The largest ever constitution bans 13 judges. Maybe he had arguments in Keshavananda Bharati versus State of Kerala case citation All Indian Report 1973 Supreme Court 1461 page number. So this page prescribes, so this is the glaring example in terms of Supreme Court reviewed the decision in Goloknath versus State of Punjab. How to review and how to applying power in terms of the doctrine of basic structure abrogated in this case. And considered the validity of the 20 and 25, maybe 24th, 25, 26 and 26th amendment of the Indian Constitution. Whether this is the unconstitution or the constitutional mandate, whether this is valid or void, that should be the question may arise before the case in terms of before the code in the case Keshavananda Bharati versus State of Kerala. So the 27th, 24th, 25 and 26th and 29th Amendments. The code held by the margin of 7 to 6 that all the no part of the Constitution, including fundamental rights, was beyond the amending power of the Parliament, thus overruling the 1968 case. The basic structure of the Constitution could not be abrogated even by constitutional amendment. Oh my God, what an approach played by Keshavananda Bharati case. The decision of the charges is complex, consisting of multiple opinions, stacking up one complete volume in the law report of Supreme Court cases. The findings includes what exactly the outcomes, and the findings included following. All of the charges held that the 24th, 25th and 26th Amendment Acts are valid. Oh my God, this is the fucking judgment in the arena, in the, what can say, history of Constitution in India. 10 judges held the Goloknath cases was wrongly decided, and that an amendment to the Constitution was not a law for the purposes of Article 13 maybe. Of course 13. 7 judges held that the power of amendment is final and can use to be amend all the articles of the Constitution, including the fundamental rights. Oh my God, what a fucking judgment. So it's what an approach. This is the fucking judgment in the whole world. Not in Keshavaranta, Goloknath, Anwar Hussain in our country. Those are the, what can say, under the ambit of the dirty politics. This is the outcome of dirty politics, nothing else. So 7 judges held, 6 judges dissenting on this point that the power to amend doesn't include the power to alter the basic structure of the Constitution so as to change its identity. 7 judges held, 2 judges dissenting, one living in this point often that there is no inherent and implied limitation on the power of the amendment Article 368 of the Indian Constitution. So what an approach. So no one what is watching this video. This is the sham for the whole nation. 9 judges, including 2 dissenters, signed a statement of summary of the judgment that reads, Goloknath case is overruled. Oh my God. In Keshavananda versus State of Kerala overruled the Goloknath case. Oh my God. And Article 306, for example, Mujib was overruled from the side of the 5 August approach. And Mahatma Gandhi was overruled, and everything will be overruled, whether this is the Rabi Thakur, whether this is the Halal Hafiz. No one actually is in apex. This is the overruling processes will be practiced in the world and is being practiced in the whole world. Article 368 doesn't enable Parliament to alter the basic structure or framework of the Constitution. Section what exactly and the 20B, what exactly 20th Amendment 1971 is valid. I don't know where they found that the section. Of course, those are interchangeably changed as to the article. The first part of the article of the Constitution, 12th Amendment 1971, is valid. The second part, namely, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court of the crown that it doesn't effect to the such policy is valid. The Constitution 29 Amendment Act 1971 is valid. The ruling thus established the principle that the basic structure cannot be amended on the grounds that a power to amend is not a power to destroy. Of course, this is the challenge towards the Mr. Alirias. So this is the hampering and defining the basic structure, the supremacy of the Constitution, Republican democratic system that should be understood. An emergency in 1975, and what is how gradually development of this doctrine. It is quite clear evolution of this doctrine is very much impact in our society. And recognition in which country that but recognition. The first of all, the India practices in this regard, and then Bangladesh and Bali's. So what exactly then Bangladesh? Anwar Hussain Chaudhary versus Bangladesh 49. No, maybe 41, Delhi Appellate Division, page number 165. This is the practicing, and this is the judgment in which this is quite clear. So the what exactly the basic structure about Constitution, the preamble and Article 7B, those are not amended by any act of the Parliament and the President, the what can say politician. But it is the major hope is that this is the 5 August prescribed the doctrine of necessity may arise in terms of what exactly the 5 August Dafa Act and Dabi Act. So Bailey's practice in this, the basic Istaq doctrine was invoked by the Supreme Court of Judicature of Bailey's in Brown versus Attorney General, and rejecting the Bailey's Constitution 6th Amendment Bill 2008, this recent judgment, which had sought to exclude the sworn deprivation of property rights from judicial review. The court recognized the fundamental rights granted by the Constitution, respect for the rule of law, and right to the ownership of the private property as basic feature of the Belizean Constitution, as well as the separation of power. With Chief Justice Abdullah what except the Conte noted had been recognized by the Judicial Committee of the Privy Council in Hinds versus the Queen, which was not a constitutional amendment case as implicit in Westminster Model Constitution in the Caribbean Commonwealth realm. The Supreme Court affirmed the doctrine is British Caribbean Bank Limited versus H.A. Bailey's and struck down the part of the Bailey's Telecommunication Amendment Act 2011 and Bailey's Constitution 8th Amendment Act 2011. Oh my God, the amendment had sought to preclude the court from deciding whether deprivation of property by the government were for the public purpose. Oh my God. And to remove any of the earlier pins identified as a part of the basic structure of the Belizean Constitution. On appeal, the Court of Appeal reversed the decision of the Supreme Court, ruling that the so-called basic structure doctrine is not a part of the law of Belize and doesn't apply to the Belize Constitution. So there is no way applying this situation. And not only that, the Cyprus actually prescribed in this recognition. So how can actually the recognition made in Cyprus? The Cyprus Supreme Court used in basic structure doctrine in 29 October 2020. So the recent case law and the recent trend, so not just those who are the law students, as you are the professor of law, as you are the judges, and you are the students of law, and you are the chief justice, how whatsoever, you must have knowledge in terms of the recent trend in terms of law starting process, whether you are the chief justice, how whatsoever, there is no media. You must have knowledge in terms of the recent trend in the arena of the case law. So the Cyprus Supreme Court used the basic structure doctrine in 29 October 22. Oh my God, 2022. And what exact the landmark decision and to declare an exact unconstitutional and constitutional amendment that modified the election legal framework. So as you are the students of Dhaka University, Asha, and where, oh my God, wow, so this is fantastic, Asha, fantastic. You are the students of Dhaka University and you must have knowledge in terms of the doctrine of basic structure exactly. If not, it will be the hampering system like the Mr. Alidias. So Israel prescribed not only that Cyprus, not only India, not only Bangladesh, but Israel prescribed the Supreme Court of Israel in majority judgment on January 1 and 2024, maybe 2024. This is the written chance in terms of the basic structure. So how this Bangladesh prescribed and Bangladesh practicing then that the 2024 in terms of 5 August, Dafa Ek, Dabi Ek. So this is the hampering system towards the Alirija, how to change and how to amend the constitutional approach. Oh my God, Akimul is prescribing the system very well. As you have all the students of Dhaka University, as we are the students of Russia University, and we are the teachers to teach the whole world, not to the actually Bangladesh perspective. Now the question matters in terms of how the recognition practicing in recognition systematic way in terms of Israel. The Supreme Court of Israel in majority judgment on January 1, 2022 ruled against the amendment passed by the Parliament in July 2023, which scrapped the reasonableness clause used by the court to overturn government decision deemed unconstitutional on the ground that it doesn't favor an unprecedented damages to the basic characteristics of the state of Israel as a democratic state. So democratic process is under the ambit of the basic pillar or the basic feature of the constitution. But in developing country, democracy is a fucking approach. This is the real scenario in the whole world. So this is the systematic way. So Israel practiced in such a way. And not only that, in Malaysia, the basic feature doctrine was initially found to be inapplicable by the federal court in Fang Sin Wang versus Public Prosecutor. The court remarked that the Indian constitution was drafted by Constituent Assembly, representative of the Indian people in territorial, racial and community terms, and not ordinary morals, while the same could not be said for the Malaysian constitution. Please sound please. And which was enacted by the ordinary legislature. So what exactly the thematic approach from the side of Malaysia? The basic structure doctrine was first started with the approval of the federal code in Obiter Tikta, in Sibasha, Russia, and the Badan, oh my God, Peguam, or Malaysia, before ultimately being applied by the same code in Seminia. Just the verses. What exactly does what can say what's name Pantabid Tana versus Taria Tanka and this another case. And in several judgments in Malaysia, in those cases the federal court held that the fasting of the judicial power of the federation in the civil codes formed part of the basic structure of the constitution and could not be removed even by constitutional amendment. So this is the simplicity. And not only in Pakistan, the basic structure doctrine was recognized in Constitution Petition number 12 of the 210, etc. by the Supreme Court of Pakistan in 2015. The case was heard by the full 17 members bench, of which a popularity of 8 accepted in the basic structure doctrine as a basis for limiting the ability of the Parliament of Pakistan to amend the Constitution. For rejected the premises of such limitation, describing the basic structure doctrine as a vehicle for judicial aggrandizement of power, and Pipe accepted that some limitation exists but didn't endorse the basic structure doctrine. The judgment identified democracy, federalism, and independence of the judiciary as among the characteristics protected by the doctrine. And not only that, this is the Singapore, that the politicians which practice and radical politics, they can make Bangladesh Singapore. So in this Singapore, the High Court of Singapore denied the application of the basic feature of the doctrine in Singapore in Teo Show Lang versus Minister of Home Affairs. Why? We don't know this is. Justice Frederick Arthur Couture held that the doctrine was not applicable to the Singapore Constitution. Why this is not known to us? In 2015 decision addressed the issue directly and accepted the doctrine. But this is the Pakistan system. But it cannot be said that our parliament's power to amend our constitution is limited in the same way as the Indian parliament's power to amend the Indian constitution. So parliamentary supremacy will be practiced in Singapore. So, and not only the UK parliament actually can a lot of things. They have a lot of powers to kill all the boys and girls. And Uganda prescribes in December 2017, the Ugandan parliament passed a constitutional amendment which removed the age limit of 75 years for the president and chairperson of the local council. The presidency, what can say, Yoweri Museveni, what exactly the naming just say, Museveni, who has been president of Uganda since 1960. Oh my God, 86 maybe, just the hearing system is not recalled. Signed the amendment to law into the January 2018 as it 74 years. Unsubstantiated evidence is available that the alleged dictator is in his late 18. Several opposition leaders and the Uganda Law Society challenged the constitutionality of the amendment before the Constitutional Court, which majority upheld the validity of the amendment, tracking not of the judgment in Keshavananda Bharati versus State of Kerala and Minerva Mills versus Union of India. Following the approaching from the side of the judgment to recalling system from the Supreme Court of India and applying the Constitution and the mandating system in terms of Keshavananda Bharati versus State of Kerala and Minerva Mills Limited versus India. The Supreme Court of Uganda is what exactly Mabi Rizi Kiwanuka, oh my God, what a difficult name, and others versus Attorney General unanimously upheld the Constitution Court majority finding. So this is the systematic way in our Constitution mandate, but unfortunately our country practices and talking of basic structure is very much difficult, and our government will make it very much difficult towards the state, what can say, other politicians like PNP, Jamaat Shibir, and every political parties to not to amend these situational cases in terms of basic structure. But this duty is entrusted to Mr. Alias, so it is the hope for us, and it is the duty to implement how to amend this systematic way in terms of tracking under the ambit of doctrine of necessity. So this is the very much difficulty which will be arised to Mr. Alias, and it is the hope for the whole nation how to amend the constitution and how to solve the problematic issue. This is the wrapped constitution will be chance. So today's Namo, this is the lighting system, and we need to enlighten the society, and lighting may become in the light of ours, in the life of ours, and this is the hope from the side of the Lord Actor. And today's Namo, bye bye.